Good afternoon, everyone. Good afternoon, everyone. Please, if you can hear me, just indicate in the chat box.
Good afternoon.
I welcome each and every one of us to the day 3 of the Hilton Top Solicitors Female Virtual Internship. So let's start with an opening prayer, please. In Jesus' name, Father, we thank you today for bringing us all together. We return all the glory to you. Lord, as we start to ask that you begin with us in the name of Jesus. For in Jesus' name we have prayed. Amen. Now I'll proceed to reading our learned SIG profile for today. So you're welcome. Profile of Akim O. Apomede, Esquire, BS Honors, LLB Honors, LLM in view, BL, ICA, Principal Counsel A.O. Apomede and Co., and formerly Chief Executive Officer of IFPI Nigeria, the Nigerian branch of the Global Record Industry Watchdog, based in London. Akim O. Apomede, Esquire, started his professional life in IPR and anti-counterfeiting field with the Nigerian National Group of International Federation of the Phonographic Industry, bracket IFPI, close bracket. IFPI is the body representing the global record industry, particularly in the area of copyright protection and enforcement. He was at various times a member of the Lagos State Anti-Piracy Committee, National Anti-Piracy Committee, spokesperson to Business Software Alliance, the umbrella body for multinational software developers and their hardware partners, including Microsoft, Adobe, HP, ETSA, Apple, etc. He served as a consultant to the World Bank on the music and film industries in Nigeria and was a consultant to the Motion Picture Association, the Global Anti-Piracy Association representing major film studios. He was also at a time in charge of the Enforcement Department of the Nigerian Copyright Commission. Akim is a member of the prestigious United States IVLP Aluminium Association, having participated in the State Department Protection and Intellectual Property Program in 2009. He is a member of the Anti-Counterfeiting Committee of the International Trademark Association and is currently the co-head of the African Global Advisory Council of that organization for 2020 till 2021 term. Akim is a 1988 graduate of Ondo State University, Ede-Ekiti, where he bagged a BS honors in political science degree. He obtained an LLB honors law degree from the University of Lagos, Akoka, Nigeria in 2004, and attended the Nigerian Law School in 2004/2005. He was enrolled as an advocate and solicitor of the Supreme Court of Nigeria in 2005. He founded AOA in 2005. He is a fellow of the Institute of Corporate Administration. He is presently studying for LLM in taxation law. Akim has served as a resource person at several workshops and conferences in and outside Nigeria. He is a sought-after speaker on IP law, especially copyright law, anti-counterfeiting and brand protection. Akim is a recipient of several awards and honors. He is widely traveled. He founded the law firm of A.O. Apomede and Co. and is responsible for providing leadership to the firm's management. His appointments are as follows: 1990 to 1994, Assistant Coordinator, IFPI Nigeria. 1990 to 2001, Head, Anti-Piracy Committee of the Nigerian Association of Recording Industry. 1993, Member, Study Group to Ghana on the Bandero Anti-Piracy Security Scheme. 1995 to 1997, member Lagos State Anti-Piracy Committee. 1997 to 2000, member National Anti-Piracy Committee. 1997 to 2000, member Technical Implementation Committee on the implementation of the hologram anti-piracy security system. 2000, initiator, Nigerian Copyright Commission Port Monitoring Scheme. 2002, consultant to the Nigerian Copyright Commission on Anti-Piracy Matters. 1994 to 2005, national coordinator, CEO, IFPI Nigeria. 2005 to 2007, consultant, IFPI. 2004, member, IFPI's committee for the drafting of the copyright, optical disc replication, regulation registered in 2006. 2006-2008, spokesperson for Business Software Alliance in Nigeria, representing multinational software producers and their hardware partners, including Microsoft, Apple, Adobe, HP, and Toshiba. 2009 to 2011, technical advisor and head of enforcement management, Nigerian Copyright Commission. 2011 till date, vice chairman, ROO Apomede Foundation, initiator of intellectual property, IP, clubs in secondary schools in Oyo, Ogun, and Lagos states. 2012 to 2015, anti-counterfeiting consultant to Mary Kay Incorporation. 2012 to date, anti-counterfeiting consultant to Nick Incorporation. February 2012 to 2006, member Board of Trustees, Entertainment Foundation of Nigeria. 2012 till date, company secretary, Lance Rock Limited. June 2013 to date, company secretary, Kajap and Engineering Services Limited. March till June 2004, person to Oyo State Delegation to the National Conference 2014 till date, member, Board of Trustees, Hope in God Foundation. 2014 till date, director, Keystone Limited. August 2014 till date, consultant, Yoruba Video Film Producers and Marketers Association of Nigeria. May 2015 till date, initiator, National Patriotic Project. February 2015 till date, consultant to the Performing Musicians Employers Association of Nigeria, PMAN. November 2015 till 2016, IP consultant to the World Bank on the music and film industries in Nigeria under the Growth and Employment Protect Project. January 2016 to December 2019, member Enforcement Committee to the International Trademark Association. August 2016 to June 2018, co-opted member, National Executive Committee of the Nigerian Bar Association. April 2017 till date, member, Board of Trustees, Ebenezer Obey Music Foundation. October 2018 till date, company secretary, NNPC, CMC, FZE, Dubai. January 2020 till date, company secretary, Daylight Development Nigeria Limited. January 2020 till date, member, Anti-Counterfeiting Committee of the International Trademark Association. January 2020 to 2022, co-chair of the African Global Advisory Council of the International Trademark Association. January 2022 till date, member, Corporate Committee of the International Trademark Association. October 2020, initiator and resource person, U.S. Embassy /NJI/INTA ACC, organized IP workshop for Federal High Court judges /Court of Appeals Justice. You're welcome, sir, to today's section.
Thank you so much.
You're welcome.
Thank you very much, my dear lady. We have spent so much time on introduction that we have taken almost 15 minutes out of my time. I will learn how to bridge this thing next time. So I greet you all and good afternoon to you.
Welcome, sir.
I think without much ado, we should go straight into the business of the day. But before I do that, please allow me to first commend the initiator of this program, my dear friend and colleague, Mrs. Deborah Oni. This is a very wonderful initiative. Mentorship is one of the missing links in our profession, and successive presidents of our national association have always hammered on the need to engage new wigs and aspiring wigs with regards to mentorship. So for you to think of this idea and consistently you've been carrying on this program. This is my second time of featuring as a speaker. I want to thank you. I believe that posterity will speak well of you when the time comes. And I also thank you for counting me worthy to make a presentation at this event. From my resume, you will realize that I am more of a mechanic than an engineer. I am a hands-on person when it comes to intellectual property rights. I am in the thick of it. I have represented, by the grace of God, a number of rights owners. I have taken part in the drafting of some of the legislative instruments. I have taken part in the enforcement of intellectual property rights in the country in various genres and various forms. So I may not speak as a lecturer, rather as a teacher, giving you information from the research of what I have seen in practice. So you will pardon me if I'm not citing authorities, if I'm not quoting judges or some authors. But I believe I'm going to do well because the essence of this program is to impart knowledge. It is for you to understand what we are talking about. Whenever you come across a textbook or any write-up on any aspect of intellectual property rights, you should be in a position to understand what they're talking about. The reason is that, and I'm sure that some of you will have come across this too, from the reaction of some of your mates when it comes to picking a course in IPR. Some see the subject as difficult. Some see it as civil science. Really, it is esoteric, I must tell you, but it is quite understandable. And I'm going to try as much as possible to break it down and get you to understand the subject matter. Mrs. Oni and those assisting her have made my job much easier. They gave me topics, and I'm going to stick to the topics that they have chosen for me. And that is why I titled my presentation as basic intellectual property rights, basic knowledge in intellectual property rights. Are you all with me?
Yes, sir.
All right, thank you very much. I want to be sure that I've not been talking to myself. Now, what is intellectual property rights? To understand what intellectual property rights, which I will answer from time to time be calling IPR, you need to understand that God, in his infinite mercy, endows different individuals with different abilities. Now, with these abilities, some can sing, but they cannot write music. They cannot create music, but they have very sonorous voices. Some can write songs, they can create songs in their heads, but they cannot sing. Some can write letters that you will read and you will laugh. Some you will read and you begin to shed tears. Some can create films and some can act. Some can look at the society and say, look, it takes 5 minutes for a boiling, what do you call it? Electric kettle. It takes 5 minutes to boil water where it's full. I can improve on it and make it to boil water within 1 minute. Now, all this are creative endeavors. Some will design a particular clause, and when it is now manufactured, people will prefer to buy that rather than buy some other types of designs. Some will say, look, we should do the logo of our product this particular way. Take an apple, draw it up, and remove a part of it as if it was bitten. And let's make that the logo of our company. All this comes from the mind. And it is God-given ability. When you now apply what God has given to you, and in your society, the law now says when you make such inventions, such creative works, you must be protected against someone else who was not part of the creation, but who wants to take advantage of it. So when I now tell you that intellectual property rights, that they are the rights given to persons over the creations of their minds, I believe that my illustration will help you in understanding the definition. There are different types of definitions that have been given, but these facts run across all of them. One, they are rights, intangible rights. They are rights. That is one. And they are rights that are vested in persons over the creations of their minds, the products of their intellectual exertion, intellectual endeavors. And those rights are conferred by law specifically. So those laws state the parameters within which the individual can enjoy the rights conferred. For how long, within what territory, what are the limitations? And this right talking about exceptions. So that is the basic definition of intellectual property rights. Hello?
Hi, sir.
Thank you. Those rights are given exclusively to the owner of the work. I use the word owner because sometimes the creator of the work may not be the owner of the work. The creator of the work is always and usually the first owner of the work, the first owner. But because it is property, intellectual property is property like any other property, other than the fact that it cannot be touched, it is intangible. It can be, means that it can be sold. It can be used as security to obtain a loan. It can be passed on upon someone, upon the owner's death. So if the creator, being the first owner, transfers his ownership to someone else, then the new owner begins to enjoy all the rights that the creator will enjoy, other than what we call the patrimonial right, which is the right to have his name shown on the work that he created the work. And other economic rights, the new owner begins to enjoy. Now, there are different types of intellectual property rights. Some divide IPR into two broad categories: copyright on one side and industrial property rights on the other. Now, when it comes to copyright, it's just a type of IPR itself that protects original works of authorship. As far as our own law is concerned, and for any country that is a member of the Berne Convention, that right, the author begins to enjoy it right from the moment that work is fixed in a tangible form of expression. It is not subject to registration before he begins to enjoy the right in copyright. Under the Copyright Act of Nigeria, there are 6 broad categories of works that enjoy the protection of the law. You have a literary work, you have artistic work, musical works, you have broadcasts, you have sound recordings, and you have cinematograph works. All these works, the rights that the authors who are the first owners, the rights that they have, which subsequent owners continue to have when it comes to economic rights, is the right to authorize the doing of anything with the works. Meaning that, as some say, it is a negative right. Negative right in the sense that it is enjoyed by stopping people from taking what belongs to you. So if you are an author of a book, or you are the corporate owner that is in a book, you have the right to stop anyone from reproducing that book, from turning that book into a movie. A number of things that others will want to do with books, they cannot do any of them unless they obtain your consent. Any of these topics is like the master's thesis on his own. So because I have less than 1 hour left now, as I said, I won't go into details. So I'm defining what these types of IPR, what each one of them is. Then trademarks. There are different products that do the same thing, perform the same function. For instance, beverage, cocoa beverage. When you open a can of Milo, what you find there is cocoa beverage. When you open Bonvita, it's cocoa beverage. Ovaltine is cocoa beverage. But when you have money to buy any of them, why do you go for one? Why do you go for a particular one? It is a function of trademark. Because proprietors of trademarks place marks, signs, or names on their products to distinguish them from the products of others. To say, if you want mine, this is the name I bear, this is the sign that it carries. This is the mark that you look for. When you want to buy Milo, and you get out there in market, when they show you Bonvita, say, no, that's not what I'm looking for. I want Milo. They show you Ovaltine, no, I want Milo. So trademarks, a trademark is a sign that is applied on a product to distinguish that product belonging to one particular person, whether it's an individual human being or a company, from those of other companies or other enterprises or other individuals. That is what a trademark is. It is to distinguish products. And it is registered. It is when you register it that your product begins to enjoy the protection of the law that governs trademarks. Without registration, you cannot sue anybody for trademark infringement. Then patents. A patent is an exclusive right. Just like I mentioned to you that IPR is exclusive to the owner. So patent is also an exclusive right, and it is granted for an invention, which is a product or a process that provides a new way of doing something. If today, any of you ladies, in spite of being legal gurus, you have a visitation by the spirits that you have a way of cooking okra soup with a machine in a manner that has not been done before. Or if it has been done before, it's an improvement, it's a new way of cooking it, and you come up with that machine, it will be registered under the law that governs patent registration. And you'll be given that protection. No one else can wake up tomorrow to want to make a similar invention like that, unless the person wants to make one which will be an improvement on what you have done. Industrial design. In my introductory statements, I mentioned industrial design in terms of cloth. It is a process of design applied to physical products which are to be manufactured by mass production. So if you creatively put features and forms on a paper and you design it, and it is now applied to the making of whether it is glass, whether it is furniture, whether it is cloth, and it is to be mass produced. The law grants you protection, exclusive protection. I want you to know that we are talking about what should be. I'm quite aware that some of you know that some of our traders in Nigeria do pick one cloth and go to China and say, "Oh yeah, produce this type of cloth for me." And they bring them here, flood the market. That is an infringement of the rights, the IPR of the person who originally designed that cloth. Then you have geographical indication. We must have heard of Gari Jebu before, of Pada rice, Igbimo rice. These are places in Nigeria that are associated with some agricultural products. And I'm sure you've heard of champagne before. Champagne is a drink, but it's also the name of a region in France. That region, the type of berries that they produce there that are used in making a type of wine, you cannot find that particular agricultural product elsewhere in France or anywhere else in the world. So when they make wine from the crops harvested in Champagne region, So the taste is different. And so they call the champagne, they call the wine champagne. But there are different types of champagne depending on the manufacturer. This particular type of IPR is never given to an individual. It's usually because one person cannot take over what belongs to a entire community. But the only thing is that you cannot be producing Gari in Ibadan and call it Gari Jebu. If you are producing Gari in Ijebu and your company's name is Sloan, you can call your own Sloan's Gari Ijebu. Another person is producing Gari Ijebu in Ijebu, and the name of his company is Textile. He can call his own Textiles Gari Ijebu, but you cannot be in Lagos and you are manufacturing Gari and you call it Gari Ijebu. So in a nutshell, a geographical indication is a name or sign that is used on products which corresponds to a specific geographical location or origin. You must have also heard of Scotch whiskey. That is the UK, from Scotland. Then you have plant varieties. As I mentioned earlier, the gift to create intellectual works is given by God. Someone will look at two plants and he will join them together, and from there, he will bring out a new plant entirely that is neither A nor B, and to be distinct from the two of them. You have plant breeders like that. The same way we have animal breeders like I mentioned. Law must protect such people because what they are doing is creative. So last 2 years ago, 2021, the Nigerian government enacted a law, the Plant Varieties Protection Act, to protect such people. I don't want to go into some others like trade secret confidential information because there is a controversy as to whether this qualifies as IPR or not. And my position is that they do not. In the sense that there is no, other than other common law, there is no specific statute that confers protection on trade secrets and confidential information. Are you with me? Hello? The person I've been talking to myself.
No, sir, we can hear you.
Oh, all right. Okay.
Yes, sir. Please go on, sir.
Okay, thank you. Thank you. Now, IPR infringement. Liabilities and remedies. I will just tell you broadly that there is an infringement of IPR when there is and unauthorized use of protected works. When a work in which the law has granted protection to the owner is used without authorization and it does not fall under any of the exceptions recognized by law, then there's an infringement and it is actionable. But I must also quickly say that the liabilities and remedies available, they differ as to what type of work has been infringed. When it comes to copyright, the law provides for both criminal liabilities as well as civil liabilities. Someone who infringes on the copyright in any work, whether it is corporate or individual, the person stands the risk of going to jail. If it is a company, there's a provision for corporate liability, corporate criminal liability. The officers of the company that had knowledge of the infringement, they stand the risk of going to jail. And the law recognizes a distinction between the maker, the manufacturer of infringing articles, as well as the sellers of infringing products in copyright. The laws that govern the different types of industrial property rights, trademarks, industrial designs, patents, and the rest, they do not provide for criminal liability. But when it comes to infringement of trademarks, even though the Trademark Act does not provide for criminal liability, there is a law called the Merchandise Marks Act, under which a trademark infringement attracts criminal liability. But generally, whether it is copyright, trademark, patent, or the rest, when it comes to civil liability, the following remedies are available: damages, conversion or delivery of. And all these I'm mentioning, they are remedies that are available when you go to court. I'll go back to my experience as a practitioner when it comes to criminal enforcement. Let me quickly mention these civil remedies. Conversion or delivery of meat is this. If somebody goes to Taiwan and brings 100 tons of this, which constitute infringement of industrial design rights of Mrs. Oni. If Mrs. Oni goes to court and these products, she is able to lay her hands on them to seize them, one of the remedies that she can seek from the court is that the court should order, after finding that the person who brought them from Taiwan has indeed infringed their rights. One of the remedies is to say, order that these products, that these 100 tons of this lace should be given to me, should be handed over to me. So that is conversion or delivery. It will be delivered up to her. She becomes the owner of those products. If she wants, she destroys them. She wants, she sells them. That is conversion. Then the account of profit. She can also ask the court to order the infringer to give an account of how much he has made from the sale of the infringing articles. And she can obtain an injunction to restrain the infringer from further infringing on IPR. She can also ask the court to make an order, especially where the infringing article is of such a poor quality that she does not want to affect her product. She can ask for an order that the product should be destroyed. There is a popular type of remedy that is usually used, usually applied in IPR enforcement, which is called anti-umbrella order. It is an order of the court permitting the right owner, with the help of law enforcement agents, to gain access into the premises of the infringer, to inspect the premises for the purpose of seeing whether there's any infringing article kept inside the premises or not, and to seize whatever infringing article that is found there and bring them to court. This type of order is usually applied for in order to stop an infringer from running away or keeping infringing items, counterfeits that are in his premises. Because when you go to court and you serve that infringer your auditing process, he knows that you are suing him or her. So if he's not a fool, he will hide what he has, he will take them away, and they will be lost forever. So anti-umbrella order is a tool for gathering evidence. Now, but the practical things that people do this is because our courts have become so busy that, one, it takes a long time, sometimes, before you can get this anti-umbrella order. Is usually an interim order that you apply for by means of an party application. And sometimes you are not sure if through the court class information will leak to the target. So what many people, many rights owners do these days is to write petitions to law enforcement agencies like the police, like NAFDAC, if it relates to medical medicaments and food and beverages. And then they now go with you to the target. They will be armed with a search warrant and an arrest warrant. And then they go there, they make decisions, and they bring them you now can file your originating process, and the police will serve as your witnesses. The product seized will be brought as evidence. Recently, I was before a federal court judge who with due respect, I'd never seen that type of procedure before. And to him, he was very conversant, very conversant with the provisions of the Trademark Act. So he knew that there is nowhere in that law where police officers are permitted, empowered to enter into any premises to make seizures on trademark infringement. So he felt that what we did was wrong. But meanwhile, we did not take actions on the basis of the Trademark Act, but on the basis of the provisions of the Merchandise Mark Act. So you need to understand the procedure. Let me proceed quickly further because time is no longer on our side. Licensing and assignment of intellectual property rights. This is the crux of the matter. When you are talking about profitability in creativity, it is in licensing and assignments. Because, as I said, infringement is where you did not give permission. Licensing is when you give permission. Assignment is when you sell, when you transfer. And all this is pecuniary. It is a mercantile issue. It is not, this man is from my village. If someone finds your creative output good enough to approach you to have, then you must be ready to pay for it. So if you have written a novel or a play that someone finds to be good enough to turn into a movie, then the person must pay for it. That is where it becomes profitable. So you license your work by granting permission. And let me tell you, especially when it comes to IPR generally, it's so broad. Your rights are so broad. They cover the entire world. And again, let me clarify that. When it comes to trademarks and patents, they are territorial. If you register in Nigeria, you do not register in Ghana. Someone can go to Ghana and register what you have not registered here. So when you know that you have something that is valuable in your hand, you try as much as possible to register in all territories of the world. Thank God for the Madrid Protocol on trademark. There are some countries that Nigeria is not part of them. If you register in one country, you are registered in so many other countries because they are all members of the same, let me say, club. Now, when you want to give someone a license to use your work, you have a right to say, I'm giving you rights to use it only in Nigeria. It does not cover legal Benin. You can say, I give you a license for just 2 years, not 3. It can be 1 year. So you can restrict the scope of the license that you give. When it comes to copyright, when you give someone a license. The license, say for instance, you wrote a book. You can give someone a license to turn it into a movie. And you can say it does not cover live performance of any play out of this novel. You can give the license for live performances of the novel without giving such a person the right to turn it into a movie, into a cinematograph film. I got it for 3 years. Because I'm giving you only for the region for Europe. It does not cover America. No, I'm not even giving for the whole of Europe. It's just for France alone. When it comes to assignment is a total transfer of your rights. It's a total transfer of your rights. But as those rights are divisible, as I mentioned earlier on, in terms of territory, so in terms of the scope, you can also say, I'm assigning to you only the right to turn into a movie. And as you know, when you make a transfer, there is no relational interest anymore. So that person to whom you have assigned a particular right has it for life. The only thing is that if it's not a total embodiment of all your rights that you have transferred, that person cannot go outside the scope of what has been transferred to him to now begin to enjoy something else. But I must make 2 caveats quickly here. Number 1, not all works require the use of a license. If your work has already entered into what we call public domain, whoever wants to use it does not need to come to you for a license anymore because it's already there. It belongs to the society at large. That is 1. Then when it comes to assignment, there is a concept that they call collective management of copyright. And what is collective management of copyright? Take the area of music. Today we have more than 100 FM stations in Nigeria. The concept of collective management of copyright in music is predicated upon the fact that FM stations use music to sell their products, their stations. I'm not sure whether up to 10% of my audience are aware that there are some stations that are called AM stations because nobody listens to them because they do more of talking and less of music. Most of you that listen to radio stations, you listen to radio stations that play more music than those who play less music. So advertisers also rush to such stations. So if you are making money through works of some others, then you must pay from the advertising revenue that you're making. That is the concept. But now imagine that every musician in Nigeria, every music writer, every music publisher, every label will now go from one station to another every year to demand for their remuneration. There'll be chaos. So the law permits the coming together of rights owners of the same type to form a collective management organization. They used to be called collective society. And then they will assign their rights to that society, to that CMO. And on their behalf, the CMO will now approach the different stations to collect the remunerations, license the radio stations on behalf of their assignors. But now, by calling it as an assignment, it's just a technical word because it does not mean that the right owners have sold their rights to this body. Because if you feel that if there are two societies, there are two CMOs in a country, and you don't feel well represented by one, you have a right to pull out and go to the other place and now assign your right to that other one. But you know, that is contrary to our understanding of what assignment stands for. Because once you have sold, once you have transferred, once you have assigned, you cannot have it, but it's no reversionary interest. But when it comes to CMO running, CMO administration, assignment does not mean complete transfer of the rights. Are we together?
Yes, we are, sir. Because they are all muted, you can't get their response. But
I know, but I still want. Yes, okay. I know, but I will be asking that question from time to time.
Very well, sir.
I know.
Thank you.
It's okay. Now, intellectual property and the internet. I am thankful to God that I did not come earlier than now. If not, I wouldn't have known, you know, what magic the internet can do. Is there anything that we can get done today without the internet? I doubt it. And one begins to wonder, how were we living before? How did our forefathers live before now? Usually for you guys, I know that there are things that will mention to you, your parents will mention to you, and you will say, wow, is that possible? Now, when you have the internet, you talk about domain names. What is the domain name? There is nothing that you want to do on the internet. Say you want to conduct a search, you've heard that your speaker is his name is Akomade, and you want to Google about him. So where do you go? You go to Google. But the domain name that you will go to must be google.com. You have Akomade law. You want to search about Akomade law. You will type akomadelaw.com. That stands for the address of the place that we're going to. You know, mathematically, every address that you are going to on the internet is represented by a number. But how many people can cram the number, even if it belongs to you, if the domain name belongs to you, you can't cram the number. 15.17.36. No. So instead of that, all what you do is the name and the name that follow it after the dot. That is the domain name. It could be .net, it could be .org, it could be .com. It could even be that of a country like NG, standing for Nigeria. So a domain name is the website's equivalent of a physical address. When you use it, it makes it easier for you to find an internet protocol address. The name and an extension of that name is what is called a domain name. It's different from a website. On top of a website, when you open website, all the files inside it is what is called a website. When you go to a domain name, rather, all what you find inside when you open that address is the website. So like a house, like a physical address, every house has number 1, David Street. Number 2, David Street. Number 3, David Street. So google.com is the address, is the domain name. The door of a house, that is when you now enter the sitting room and you see chairs, you see whatever. The same way you open Google, when you have typed google.com, it opens onto you. Then you now decide what you want to do inside Google, and you now begin to open different files. And Google, which is a search engine, the files are unsearchable. They are non-exhaustive. But if it is Oyebode, Alukan Oyebode and Co., I don't know their domain name, but when you get the name dot the extension, the website will open. And then you can move from one room to another, you see what they are doing, you read about the partners, read about what they do. The same thing with Google. Accommodate, you type, no Google, if you type your URL, accommodatelaw.com, that is our domain name. And then our website will open for you, and you can enter and see what goes on there. Now, today, the internet has become the marketplace for showcasing one's talents, one's products, one's creative activities, and also distribution of IP works is done online these days. So in order to do this, every IP owner needs a domain name and needs a website. According to various reports, surveys that have been conducted, the fastest growing area of counterfeit trading and intellectual property infringement is done online, not offline. Alaba market used to be the den of music piracy in Nigeria, but it's no longer so. Illegal music streaming, downloading, and the rest is going on a very large, humongous scale now that has made Alaba piracy to be a child's play. So IP infringement, when it comes to online, it covers the sale of counterfeit products and services through the internet, and a variety of other activities, including cyber squatting, SEO, unsolicited email marketing, cyber piracy, and so on. Let's take copyright works like music, photographs, books, and so on, for instance. You will have a publisher or producer who distributes the works. Most of the distribution is now done on the internet. Music is streamed in various ways. The major challenge faced by works today is cyber piracy and online infringement. Even pirates, counterfeiters, they also need to be on the net, and so they need domain names as well as to have their own websites. They cannot do without that now. So, but what is cyber squatting? When a third party registers a domain name, and that domain name he has registered consists of or is similar to a brand name, and they have no legitimate claim to the name, then what did they do? What did they do? They try to sell the domain name to the legitimate, the original owner of the name. Let me give you an example. If you want to buy air tickets and if you want to fly earpiece, type flyearpiece.com. It will take you straight to their website. If you make the mistake of typing earpiece.com, if you type that domain name, you are likely to find that someone else has already purchased that domain name. Meanwhile, he has no business with earpiece at all. If you are not careful, if earpiece is not careful, they can sell that, the person who bought it, who registered that domain name, can sell it to an unscrupulous person who will be buying, will be selling fake tickets to people. That is one. Two, it could be bought by an earpiece competitor. When you type earpiece.com, expecting to buy a ticket from earpiece, and it does not lead you there, you are likely to go elsewhere to buy. And those who engage in cyber squatting, they also have a way of engaging in parking, which will now link you up to another airline where earpiece is not available. So those who engage in cyber squatting, they will register a domain name that is similar to your own. So what will earpiece do? Earpiece will now approach them. They might register it for $2,000. To sell it for earpiece to get it from them, earpiece may pay up to $200,000. So that is cyber squatting. Then cyber piracy. These people who engage in cyber piracy, they are criminals, unscrupulous people. They will deliberately misspell the name of a known brand. When someone is typing a domain name to search, you might be led to that particular domain name, and they will pretend as if they are the people that you want to buy from. So they may engage in phishing, obtain information for your bank statements from you, and sometimes they will sell fake products to you because you assume that you are dealing, like, say, Nike, for instance. If they take you to a website that does not belong to Nike. They will sell products that you will assume to be Nike products to you, where they are not. So there are different ways by which online infringement is carried out. Those in pharmaceuticals, these days, people buy as you buy from Konga and the rest. All sorts of infringing items are sold. They are advertised online as if they are genuine products. But when they are delivered, you discover that they are not genuine. That is one other aspect of online infringement that is going on. Now, international IP law. International IPR law is built upon several treaties, conventions, protocols, and agreements. There is an organization, which is an agency of the United Nations called the World Intellectual Property Organization. That organization alone administers 26 treaties, including the WIPO Convention itself. And some of these treaties are Berne Convention, Madrid Protocol, the Rome Convention, and the rest. But there are other treaties and conventions that are not brought under WIPO, because you have regional conventions like the Aripo Treaty, the European Treaty. So there are other conventions, but ultimately, what is our own interest as Nigerians? Any treaty that we enter into must be legislated upon by the National Assembly by virtue of Section 12 of the Constitution of the Federal Republic of Nigeria 1999, as amended. And there are two ways by which the National Assembly has done this with regards to IPR in Nigeria. The National Assembly can enact wholesale a particular treaty or take pieces therefrom and incorporate such provisions into our existing laws, amend those laws so that they will be in line with our treaty obligations. You must be aware that last year, the National Assembly passed a new Copyright Act, and that the President has assented to it. The law that was, the Copyright Act that was repealed, and this new one, they took from the Berne Convention, from the Rome Convention, which protects performances and phonogram producers, picked from the World Copyright Treaty, picked from the WPPT, the WIPO Phonogram Producers Treaty, and incorporated all these into the provisions of the law. So that at every point in time, we can say that Nigeria is in tune with the treaties and conventions and obligations of the international law on IPR. You must have heard of TRIPS before, TRIPS. TRIPS is the World Trade Organization Agreement on trade-related aspects of intellectual property rights. WTO is another agency of the United Nations, different from WIPO. But when they found that there are some aspects of intellectual property rights that there are some consequences on how international trade is organized, they have to come up with that WTO agreement. So, in a nutshell, that is international law on IPR. Now, it now comes to you and I. How can aspiring lawyers prepare for entering the IP space? The first, in my own mind, is that any aspiring lawyer must have a firm grasp of IPR. You need to understand, IPR. You need to understand it. There is no other way around it. Because when clients come, they want solutions. I introduce myself as a legal practitioner to people, to clients. I introduce myself as a solution provider. And that is what we are as lawyers. That is what all professionals are. Nobody comes to you if he or she does not have a challenge. Now, if you don't understand how to solve the challenge, how can you then provide a solution to it? If the concept itself is strange to you, I'm sorry. You need to learn more about it, or you find something easier to do. You should not ask in different areas of legal practice. Some of our colleagues, some, I'm not saying all, I'm not saying many, some, a few, end up adding to the challenge that their clients have brought to them. Some people have been condemned and have been executed just because the counsel did not understand the concept of criminal law very well. So if you want to prepare yourself for a life in practice in IPR, please endeavor to have a good grasp of intellectual property rights. And to do that, you have to study hard. You have to network with other practitioners in the field. You must be determined to forge ahead, to move on, never to relent, never to look back, never to be discouraged. Because challenges will come. You will wish to give up at a time. The briefs may not come as you expect them to come. But do not give up. Everybody knows that this is an area of law that is not yet fully developed. So count yourself lucky that you are among the pioneers. But it's not enough to say I'm a pioneer. It is very necessary that you are determined to make a good success out of it. And that is when success will indeed come. I was given another topic which is not part of the slides, and I will quickly run. I have 1 minute more. Mrs. Oni, do I have your permission to take 5 more minutes?
Very well, sir. We can go ahead.
Thank you very much.
Yes, sir.
Thank you very much. Which is oh, now I'm sorry, there are 2 other topics. Yes, competition law, competition versus IPR. Very good. You know, when I started, I said that creativity is a gift from God. And I still maintain that. Now, in order for the creator, the human creator, to benefit from his creation, the law grants him the right to a protection against someone who wants to take it from him. Because an infringer is a thief. He wants to steal. But at the same time, because it seems you lost me for a moment.
Yes, the network intercepted, so we couldn't hear you.
Oh, okay.
And so we're not seeing the screen again. You might need to reshare.
Oh, okay.
The slides.
Yes, I have come to the end of the slides.
Okay, very well, sir.
So what remains now is just for me to elaborate on the points that I have here, which I did not put in the slides.
Very well.
You know, I'm just reading the letters now. That's where I'm picking the topic from.
Very well. Thank you.
Now, thank you. Now, I said that Wizkid is making a lot of money from his music, and I'm not making such money. It's because God gave him that gift, and he decided not to give me. As I speak before you, I cannot even sing to save my own life. But when Wizkid begins to sing now, everybody will begin to dance. I'm sure that if Wizkid comes online now, some of you will abandon me and begin to listen to him. Now, the society now decides that there must be a balance. As much as the creator is entitled to a monopoly right, the society is also entitled to benefit from his creation. Law, which restricts the power of individuals or enterprises. owner, I have the right to stop people from reproducing my work. Yes, then that means that if they want to produce my work, they come for a license. So if they come for a license, I can fix my price anyhow, anywhere I like. No, competition law will stop you from doing so. Yes, you have a right to stop people, but when it comes to certain things, other than even the exceptions that have been given, you cannot just fix the price anyhow. If you do, then the competition law will come in, and that is where FCCPC comes in, the federal agency responsible for administering the competition law in Nigeria. This is where the concept of compulsory licensing comes in. When you insist that, no, I'm not going to give you my rights, I'm not going to, you are asking for, the money you are asking for is too small, then the will-be licensee has a right to go to the FCCPC, and FCCPC has now the power to enforce what they call compulsory licensing, which will make you to license at an amount that will be prescribed by the agency. Even though Section 64 of the FCCPC Act excludes licensing and assignment of patents from this. But other than that, the society tries to balance between the rights of a creator to have a monopoly right over his creation and the rights of the society, of the consumer, to say you must allow the members of the society to benefit from your work. And talking about current trends and developments in IP law, you have traditional knowledge, traditional cultural expressions, and genetic resources. Incidentally, as far back as 1992, the Nigerian copyright law had been amended to take care of folkloric expressions, because some of these things we are talking about, they are the know-hows, the skills, the knowledge that can be ascribed to people from a particular locality. They'll say, okay, this originates from this place. Like for instance, when you talk of Rara, Rara is a kind of poetic song that Yoruba people sing. It's a particular area of Yoruba where they sing Rara. So the international community, particularly the World Intellectual Property Organization, has found reason to come up with an attempt to protect such works, such cultural works. So these are the new trends in IPR today. And on that note, I want to once again thank Mrs. Oni and thank all of you, the participants, for the audience. My prayer is that you will all make a great success out of IPR practice when the time comes. Thank you once again. God bless.
Hello, sir. Can you hear me, sir?
Very well.
Okay, thank you very much, sir, for this very insightful session. We really appreciate you because we've learned so much from all that you've taught us today. So please, to our interns, if you have any questions, kindly note them in the chat box and our speaker for today will attend to all these questions. Thank you. All right, so we have our very first question from Miriam Amosu, and she's asking if a license can be revoked.
Thank you very much. The first thing you have to understand is that the basis of IPR law is the law of tort. Hello? Hello?
Yeah, we can hear you, sir. Please go ahead, sir.
Yes, it's the law of tort. Now, but when it comes to licensing and assignment, you have to take a recourse to the law of contracts. When you enter into a licensing agreement with a person, it is the terms of the licensing that will determine what governs your relationship. A license can be revoked, but under what terms? What does your contract say? What does your agreement say as to the conditions under which you will revoke a license? If it is not stated in the agreement and you revoke a licensing agreement and the other party goes to court, then the court will now be faced with interpreting that agreement to know whether what you have done is right or not. So if someone comes to you as a lawyer and says, please help me draft a licensing agreement, you must remember to put a termination clause in the licensing agreement, and you must state under what circumstances that clause can be activated. I hope you understand my answer.
Yes, sir, very much. Thank you very much, sir. So the next question is from Miss Edith Johnson. When someone writes a book, which title has already been used? Can one be liable?
There is no copyright protection for titles. So you can use as many titles. You can use someone else's title. It does not matter.
All right, sir. Thank you very much, sir. The next question is from Ms. Glory. She said, as regards industrial design, can a substantial change in color design from similar design of another be seen as an infringement?
You see, when it comes to issue of infringement of trademark, industrial design, and even copyright, substantiality is a question. Substantiality. When it comes to issue of industrial design and trademarks, the judge serving as the jury now must look at the two side by side and should ask himself, will an average person say that this was taken from this? So it depends on the way he answers the question, given what he has said. So your question now will be more easily answered if you have two designs that you are showing all of us. Then we can all look at it and say, and then we will be standing as jurors to say, oh, yes, it is similar. No, it is not similar. I hope you understand my answer.
All right, thank you.
So what I'm saying is that it's a question of fact.
Yes, sir. All right, thank you very much, sir, for such an insightful session. All the interns are very appreciative of the wealth of knowledge you've shared. From the chat room, everybody is saying thank you.
That's a Deborah. That's a Deborah who raised her hand.
Okay. Deborah, you. Okay, no, that's the managing partner, sir.
Okay, okay.
Deborah, do you want to say anything?
Yeah, sure. Thank you so much, Victoria, and thank you so very much, my own very learned colleague. Ladies, it will interest you to know that Mr. Akim O. Akomade was one of our pioneer speakers. Victoria, I don't know if you can recall, during your time, he was one of those who addressed you all on intellectual property. So we have had this continuous support for this program in empowering women in light of the emerging technology. And it will interest you to know why I keep, bringing him here. Though last year we didn't have him because, a lot of things were on board. And most of the time before I try to recall and then remember that I had not brought the expert himself on the intellectual property, it would have escaped my mind somehow because of the various changes we were making to the various topics we were trying to cover at the various editions and all that. But he's always done an amazing job on this intellectual property. And if you were here from the onset when his bio was being read out, I mean, what other thing can I say, or who else can I bring than the authority himself, the expert himself? And so you must understand by now that we don't just bring people for you to get stories or something you can just download by yourself and just read, but we bring experts in the various fields that we try to address here, so you can find very understandable, relatable, and so it can really, get down to you by them speaking from the wealth of knowledge, from the experience, and then you're able to ask questions that will be well attended to, that you could, always follow up with them to be mentored and to be directed. I recall, I like using myself as an example. Like I said, forget that this whole idea and vision was born out of the fact that I recall some of the shortcomings and some of the things that actually, prohibited me from moving faster than I should have. I have learned now, and I think I should approach it a different way by helping the younger ones to come up. I recall back then in the school, I didn't even understand the importance of intellectual property. And so I recall that it was offered as an elective during my time in the University of Jos, and I didn't even, pick it as a course. So the intellectual property was that I have knowledge of now is based on the personal, research and information and other trainings that I have been doing. Like I mentioned about WIPO, I have done some couple of trainings with the WIPO, and of course we make research and other trainings on other platforms. And so I want you to really take this serious. If it's been offered in school, pay attention. And these that you have been given here is not, trust me, you can't get this from your classroom. This is a wealth of knowledge. This is knowledge personified. This is a package of someone that has gained the experience and is keen to you as a practicing lawyer, someone who has experience. It's a different thing for you to have the training. I mean, I cannot in any way compare myself near Mr. Akim or Akomade. Apart from the fact that he's a learned serious senior, he knows his job in this space. This is what he lives for. This is what he does. And so he has a very vast knowledge of the intellectual property that we all are learning from, right? Opportunity and privilege to have him here today. And I believe everything he taught was well understood by us, as it was taking us through understanding the basics of intellectual property, the intellectual property rights, the various types. And I mean, I selected all the aspects that was to treat in the way, because I know that we can't treat everything, but there were basic things I needed him to touch, which he has done justice to. because in light of the digital economy, I know that if there is any aspect of law that you can't do away with is the intellectual property, right? So now the essence of this place is not to give you everything, because if we were to treat the whole of intellectual property, I'm sure Mr. Akim will not live here today. So he can only do the basic one he has done now to stir up your mind, to go and do further research. And then, of course, you can connect with him on the various social media platforms that he will probably make available for us here. And, you know, you try to follow up with him and see how you can get direction. And I know that he will attend to you by virtue of the fact that you're coming from this platform, and because he's set to helping the younger ones to grow, and so much to women, the emerging women tech lawyers. So intellectual property is an aspect that you shouldn't take for granted. And like I said, because we are focused on trying to build you and inform you and empower you and educate you in line with the emerging trend, some legal areas and aspects you cannot do away with, things like the intellectual property, dispute resolution, data privacy, data, that I have those aspects selected for us to have sessions on. And we don't treat all aspects of law, but we treat the major aspects that actually relate with you having to be able to thrive in this space as a lawyer in the digital economy. I said, also say intelligence is something that an aspiring lawyer you should have knowledge of. And I hope you have really taken advantage of what he took us on today. And I want to appreciate you, sir. Words cannot express the level of appreciation and respect that I have for you. And I know you will always oblige us each time we call upon you in the future for other editions. And I must say that personally, it was highly informative. It was highly insightful. And of course, we can never know all. Once we keep relating with people like you, we keep our memories refreshed, and we're put on track. Some of the blogging questions that we have are addressed. So I want to thank you for taking your time for this great sacrifice, which money cannot pay for. If money was to pay for it, we would not be able to afford you come on this platform. But we appreciate experts like you, without whom this platform will not be able to thrive. The impact that we make on this platform is due to the glory of God through instruments like you, sir, and we do appreciate and do not take you for granted. So on behalf of this whole Hilton Top Solicitors and the team and the interns, the amazing ladies here, and of course my team, the volunteers, I want to say thank you so much, Mr. Akim O. Akpade, for your sacrifice, for your time, for this wonderful, insightful session today. We ask that the Lord will bless you, and the wealth of knowledge of yours will not run dry, that the Lord will keep increasing you by the power of his name. Thank you so much, sir.
Thank you so much, so much, my dear sister. It's a great honor for me to be part of what you are doing. Ladies, I want you to know that Mrs. Oni is investing in your lives. And the only thing that you can do to ensure that our labor of love is not in vain is, one, for you to succeed in your endeavors. And two, for you to be another Mrs. Oni to others. You must also give back to the society. That is what this is all about. You can never tell where this is going to take you. My prayer is that when I begin to hear about each of you, it will be in high places. And that all of you will also be such people that we will be proud of, to say, yes, these are students of Deborah Oni School of Selfless Service. So on that note, I thank you again, and I wish you a wonderful continuation of this program. If I'm invited again next year, I assure you that I will make myself available wherever I am. I have a flight to catch now, but I said I must wait to finish this, you know, and then I'm rushing to the airport now. So thank you so much.
Oh, thank you so much. Like I said, once again, thank you for the sacrifice. We do appreciate you and we wish you a safe trip, and the Lord will be with you and bring you back. Thank you, sir.
You're welcome. Bye-bye.
All right. Bye.
Thank you very much, sir. Do have a lovely day, sir.
Yeah, thank you, my dear lady.
All right, everybody, we've come to the end of today's session. Thank you so much. To all the interns, your task will be assigned to you. Please remember that you have your first group presentations on Saturday. The time will be communicated to you, and I can see that you all have started creating groups and started your discussions. Keep up the good work, and we will see you on our next session. Thank you so much, Ms. Deborah. Bye, everybody.
Thank you, Victoria. God bless you, everyone. Bye.
Bye.
Yeah.